Before we begin, a quick and important disclaimer. The information presented in this documentary is intended strictly for educational, informational, and historical purposes, and it absolutely does not constitute professional legal counsel, financial advisement, or psychological therapy. The American legal system is incredibly complex, and family law statutes, mediation guidelines, and divorce procedures vary drastically from state to state and county to county across the United States. The historical trends, detailed case studies, and potential outcomes we will examine regarding alternative dispute resolution reflect historical events and general systemic mechanisms, not guaranteed results for any individual viewer. We will deeply explore the architectural flaws of the traditional legal system and the development of mediation, but any decisions regarding your own personal relationships, asset division, child custody, or financial restructuring must be made with the guidance of a licensed, qualified attorney or certified mediator practicing in your specific jurisdiction. Navigating the dissolution of a marriage carries immense legal and financial weight, and viewers are strongly urged to conduct their own thorough due diligence and seek localized professional representation before taking any action. Picture the American courtroom in the early 1970s. It is a theater of absolute destruction, before the widespread adoption of no-fault divorce laws, and long before the concept of sitting around a conference table to negotiate was even a whisper in the legal community. Ending a marriage in the United States was a brutal, gladiatorial spectator sport. You could not simply decide that a marriage was over because of irreconcilable differences or a mutual desire to part ways. The state required a villain. To secure a legal separation, one spouse was legally mandated to prove that the other was fundamentally defective, forcing couples to manufacture evidence of adultery, extreme mental cruelty, physical abandonment, or institutionalization. This archaic system birthed an entire underground industry of private investigators, staged hotel room photographs, and entirely fabricated testimony sworn under oath. The traditional litigation machine was meticulously designed to pit two people against each other in a zero-sum game, turning intimate family secrets into public weapons, all while draining the family's collective wealth to pay exorbitant, open-ended hourly legal fees. Lawyers were financially incentivized to escalate conflict. Judges were forced to make sweeping, life-altering decisions about the lives of children they had never met, and the families left behind were often financially ruined and emotionally traumatized beyond repair. Even when California Governor Ronald Reagan signed the nation's first no-fault divorce legislation in 1969, the underlying machinery of the legal system remained adversarial. The battleground simply shifted. Spouses no longer fought over who was to blame for the collapse of the marriage. Instead, they fought violently over the division of assets, the valuation of businesses, and the custody of their children. The legal system still demanded that families resolve their private pain through public warfare. But right in the middle of this legal bloodshed, a quiet, deeply subversive rebellion began to form. A small, radical faction of family therapists, rogue attorneys, and social workers looked at the devastation of the American family court system and decided to commit professional heresy. They proposed a concept so dangerous to the established multi-billion-dollar legal industrial complex that they were mocked, ostracized, and frequently threatened with disbarment. They asked a profoundly disruptive question. What if a divorcing couple could bypass the courtroom entirely? What if, instead of arming themselves with aggressive litigators and preparing for years of financial hemorrhage, they sat in a private, confidential room with a neutral third party and dismantled their own legal contract on their own terms? This was the absolute birth of divorce mediation in America. It was led by historical figures like O.J. Kugler, an attorney and therapist whose own devastating, highly litigated divorce in the early 1970s pushed him to the brink of financial and emotional collapse. Realizing that the legal system was inherently unsuited to heal family dynamics, Kugler founded the Family Mediation Association in 1974, developing the first structured model for alternative dispute resolution in family law. These early adopters were not just legal innovators. They were cultural outlaws who recognized that the state had absolutely no business engineering the emotional fallout of a dying family. They faced immense, organized pushback from state bar associations who viewed mediation as the unauthorized practice of law and a direct, existential threat to their historical monopoly on marital disputes. Attorneys argued that without aggressive representation, vulnerable spouses would be taken advantage of, ignoring the fact that the litigation system itself was already bankrupting those very same individuals. Yet, These pioneers pushed forward, developing a framework of alternative dispute resolution that fundamentally shifted the balance of power from the imposing gavels of family court judges back into the hands of the individuals, living the reality of the separation. This brings us to the profound problem this documentary solves for you today. The modern American divorce industry remains a massive wealth extraction machine, heavily weighted toward prolonged litigation that thrives on high-conflict communication. If you are a citizen of the United States facing the daunting prospect of marital dissolution, or if you simply want to understand the hidden mechanics of family law to protect your future, you are standing at a critical crossroad. The default path laid out by modern society still leads directly into the teeth of the adversarial court system. It promises a battle for justice and fairness, but historically delivers financial depletion, devastating multi-year delays, and deep psychological scarring for both the adults and the children caught in the crossfire. Even today, millions of Americans fall blindly into the trap of traditional litigation, entirely unaware of the historical manipulation designed to keep them fighting and paying billable hours. By deeply examining the historical case studies of the first divorce mediators, you are going to learn how to actively bypass this predatory machinery. We are going to deconstruct the exact negotiation frameworks that were forged in the fires of the 1970s and 80s, translating them into actionable educational insights you can use to understand modern asset division, complex custody agreements, and the critical art of conflict de-escalation. You will discover how the early adopters shifted the psychology of divorce from a posture of attack to a posture of mutual problem-solving. This is not about saving a failing marriage. It is about saving your financial future, protecting your generational wealth, and shielding your family from the brutal theater of the courtroom. We will explore the precise mechanisms of how mediation completely protects your privacy, keeping your highly sensitive financial data, business valuations, and personal failures entirely off the public legal record. You will see how historical trends prove that mediation results in far higher rates of post-divorce compliance compared to court-ordered mandates, simply because the individuals involved actually built the agreement themselves. By the end of this deep dive, you will possess a profound, structured understanding of how to take control of the narrative, avoid the devastating financial traps of continuous litigation, and approach the restructuring of your life with strategic intelligence rather than emotional reactivity. This is the untold story of the legal rebels who fought the system, changed the culture, and ultimately gave you the right to own your divorce. To understand the absolute magnitude of this shift, we must first examine the catastrophic failure of the American family court system during the 1970s. When no-fault divorce legislation swept across the nation, state court systems experienced an unprecedented, overwhelming surge in marital dissolution filings. The floodgates opened, and the legal infrastructure was entirely unprepared for the human tidal wave that followed. Courts were physically buckling under the sheer volume of cases. Dockets became backlogged for years, trapping families in a state of extended legal purgatory. The traditional litigation machine, which was historically designed to handle corporate contract disputes and criminal prosecutions, was suddenly tasked with untangling the deeply complex emotional and financial webs of broken families. Judges who were trained strictly in the rigid application of statutory law were suddenly forced to act as impromptu psychologists, making life-altering decisions about child custody and financial ruin based on brief, highly adversarial hearings. The inherent architectural flaw of the traditional court system was that it demanded a winner and a loser. It operated on a strictly binary framework. When this framework was applied to a divorcing family, the potential outcomes were almost universally destructive. Spouses were advised by their respective attorneys to cease all direct communication, effectively destroying any remaining foundation of trust. The legal strategy was to hoard information, hide assets, and launch aggressive discovery motions designed to bankrupt the opposing party through sheer attrition. Against this backdrop of systemic collapse, the early adopters of divorce mediation began to build a parallel infrastructure. They did not simply want to reform the existing court system. They wanted to render it completely obsolete for the vast majority of divorcing couples. To achieve this, they had to invent an entirely new methodology of dispute resolution from the ground up. Historical trends from the labor and international diplomacy sectors provided a baseline, but family dynamics required a radically different approach. The earliest models of family mediation mandated a structured step-by-step process that stripped away the adversarial posturing. The very first step required a paradigm shift in financial disclosure. In traditional litigation, obtaining financial records required formal subpoenas, depositions, and the threat of contempt of court, costing thousands of dollars in billable hours. the early mediators instituted a policy of radical voluntary transparency. Couples were required to bring all financial documents to the table openly, establishing a shared reality of the marital estate. If a party refused to be transparent, the mediation was immediately terminated. This single rule eliminated months of aggressive legal maneuvering and saved the family estate from being consumed by the very process meant to divide it. The second critical innovation introduced by these pioneers was the concept of interest-based negotiation, fundamentally replacing the positional bargaining mandated by the court system. In a courtroom, a spouse might take the rigid position of demanding the marital home. The opposing spouse would take the counterposition of demanding the home be sold. The judge, faced with mutually exclusive positions, would typically force a sale, leaving both parties deeply unsatisfied. The early mediators trained couples to look beneath the rigid positions to identify the underlying interests. Case studies from the early 1980s demonstrate this profound psychological shift. A mediator would ask why the spouse wanted the home. The underlying interest was rarely the physical structure itself. The interest was typically a desire for stability for the children, or a fear of not being able to qualify for a new mortgage independently. Once the true interests were exposed, the couple, guided by the mediator, could brainstorm alternative solutions that satisfied both underlying needs without destroying the family wealth. Imagine if you are an American citizen named David, living in the current year 2026, navigating the complexities of a modern divorce with his wife Jessica. They have accumulated a typical middle-class estate, a primary residence with significant equity, heavily fluctuating retirement accounts, and 2 young children. If David and Jessica default into the traditional adversarial system today, they are stepping into a machine that historically demands massive upfront financial retainers. Their attorneys will file competing motions, immediately establishing a dynamic of mutual destruction. The court will impose temporary orders restricting their financial autonomy and dictating exactly when they can see their own children. They will spend months, if not years, funneling their hard-earned family wealth into a system that thrives on their continued conflict. But because the early adopters of the 1970s fought to establish an alternative pathway, David and Jessica have the option to step out of the arena. If they choose mediation, they enter a private setting where they retain absolute control over the final agreement. Instead of a judge imposing a standardized, inflexible custody template, David and Jessica can craft a highly customized, flexible co-parenting schedule that actually accommodates their specific modern work schedules and the unique developmental needs of their children. The potential outcomes of this self-determined approach include significantly higher post-divorce compliance. Because human beings are historically far more likely to adhere to an agreement they built themselves rather than a mandate forced upon them by a stranger in a black robe. The pioneers of mediation recognized that divorce is fundamentally an emotional transition with legal consequences, not a legal transition with emotional consequences. They developed specialized techniques to de-escalate acute conflict in real time, recognizing that trauma and fear are the primary drivers of aggressive litigation. They instituted the use of neutral financial professionals to project the long-term tax implications of asset division, ensuring that neither party agreed to a settlement that would quietly bankrupt them a decade later. They created a confidential environment where past grievances could be acknowledged, but the focus remained entirely on engineering a functional, sustainable future. This was a masterclass in human psychology applied directly to the law. They were teaching people how to dismantle a legal partnership with dignity, preserving the crucial co-parenting relationship that would need to survive long after the final decree was stamped. However, this radical shift toward peaceful, self-determined resolution sent shockwaves through the established legal community. By actively teaching the public how to bypass the courtroom, these mediators were directly threatening the financial lifeblood of the traditional divorce industry. Millions of dollars in potential billable hours were suddenly vanishing from law firm ledgers. The legal establishment, deeply entrenched in its adversarial traditions and fiercely protective of its jurisdictional monopoly, realized that if mediation became the standard practice, the entire business model of family litigation would collapse. They were not about to surrender their power, their influence, or their revenue streams without a fight. What happened next was a highly coordinated, aggressive campaign to crush the mediation movement before it could permanently alter the landscape of American family law. The primary weapon of choice for state bar associations across the country was a legal concept known as the unauthorized practice of law. This was a historically established statute designed to protect the public from fraudulent attorneys and unqualified legal representation. But in the late 1970s and early 1980s, it was strategically weaponized against the family therapists, social workers, and financial professionals who dared to facilitate divorce agreements. The legal argument deployed by the establishment was rigid and structurally unforgiving. State bar ethics committees decreed that the drafting of any memorandum of understanding, which is the foundational document produced at the end of a successful mediation, outlining the division of assets and custody arrangements, constituted the explicit drafting of a legal contract. Therefore, according to the traditional legal gatekeepers, any mental health professional who typed up a settlement agreement was illegally practicing law. The potential outcomes for these early mental health mediators were incredibly severe, including historical trends of criminal prosecution, crippling financial fines, and the permanent revocation of their professional licenses. But the attack from the establishment was not just aimed at therapists and social workers. It was equally vicious against licensed attorneys who attempted to mediate cases. The traditional rules of professional conduct explicitly prohibited an attorney from representing two parties with conflicting interests. In a divorce, the legal system automatically categorized the husband and the wife as absolute adversaries. Therefore, state bar associations argued that a single lawyer acting as a neutral mediator was committing an egregious ethical violation by engaging in dual representation. If an attorney tried to step out of the gladiator role and into the role of a peacemaker, they faced severe disciplinary hearings and potential disbarment. It was a perfectly designed bureaucratic trap. Non-lawyers could not mediate because they were not lawyers, and lawyers could not mediate because the ethics rules forbade them from being neutral. The judicial system had successfully built an impenetrable, regulatory fortress around the traditional litigation model. To fully grasp why this resistance was so fierce, we must deeply dissect the fundamental economics of traditional legal litigation. The legal industrial complex operates on the framework of the billable hour, a mechanism where attorneys charge for every single minute spent on a case. This includes reading routine emails, drafting aggressive adversarial motions, waiting in court hallways for hearings to commence, and arguing with opposing counsel over the phone. A single contested divorce could easily generate tens of thousands of dollars, and sometimes hundreds of thousands of dollars, in raw revenue for a traditional law firm. Mediation threatened to condense a multi-year, highly profitable legal war into a localized, efficient negotiation spanning only a few months. Case studies from early alternative dispute resolution pilot programs demonstrated that mediation could reduce the total financial cost of a divorce by massive margins. For the traditional legal community, this was not viewed as a beneficial dispute resolution model. It was viewed as an economic apocalypse. Imagine if an American citizen named Michael in the year 2026 decides to pursue mediation to end his marriage. Today, he can easily search online databases, find hundreds of certified mediators in his specific zip code, read comprehensive reviews, and schedule a remote video consultation within minutes. The process is completely normalized, structurally sound, and highly regulated by modern state laws. But to understand the profound courage of the early adopters, you have to realize that seeking mediation in the early 1980s was an act of quiet, almost subversive rebellion. It was often conducted in the shadows. Couples had to actively seek out these renegade professionals, often through hushed word of mouth, fully knowing that a traditional judge might entirely reject their painstakingly negotiated settlement simply because of the collaborative method they used to achieve it. The pioneers of this movement, figures like John Haynes who heavily influenced the structural development of the modern mediation practice, realized they could not defeat the legal establishment through direct, head-on confrontation. They needed a sophisticated strategic workaround. They needed to systematically dismantle the ethical and legal arguments being weaponized against them. To counter the unauthorized practice of law accusations, they developed a strict, impenetrable procedural boundary. They established the fundamental doctrine that mediators do not give legal advice. They provide neutral legal information. The mediator facilitates the intense conversation, helps the couple brainstorm potential outcomes, and drafts a non-binding memorandum of understanding. They then explicitly instruct the couple to take this draft document to separate independent reviewing attorneys who formalize the final legal contract. This brilliant strategic pivot created the concept of the consulting attorney. By integrating traditional lawyers into the tail end of the mediation process as focused advisors rather than lead combatants, the early mediators effectively neutralized the primary ethical attack from the state bar associations. This strategic integration fundamentally altered the landscape of family law. Instead of freezing lawyers out of the process entirely, mediation redefined their utility. It transformed attorneys from aggressive courtroom litigators into specialized legal consultants who simply reviewed the final agreement to ensure it met specific statutory requirements and protected their individual clients' fundamental rights. This shift satisfied the ethical mandates of independent representation while completely preserving the core psychological and financial benefits of the self-determined mediation process. Historical trends show that as this hybrid consulting model gained traction, the fierce opposition from the legal establishment slowly began to fracture from within. Progressive, forward-thinking attorneys began to recognize that clients who utilized mediation were far more satisfied with the final results and significantly less likely to file malpractice lawsuits against their counsel out of sheer frustration with the broken court system. The early mediators were essentially building the airplane while flying it. They established the first professional credentialing organizations to create standardized training protocols, rigorous ethical guidelines, and peer review systems. They meticulously documented detailed case studies, tracking post-divorce compliance rates, and gathering empirical data to prove that mediated agreements resulted in significantly lower rates of future litigation. Furthermore, the early mediators understood that the most compelling argument against the traditional court system was the documented psychological devastation inflicted upon the children involved. Under the adversarial model, children were frequently weaponized, forced to undergo hostile psychological evaluations, and sometimes even called to testify in open court. The pioneers of mediation began publishing detailed reports demonstrating the positive potential outcomes of shielding children from this systemic conflict. They showcased data proving that when parents collaborated in a private, mediated setting to build a co-parenting plan, the long-term emotional stability of the children dramatically improved. This empirical data became a powerful tool against the traditionalist litigators who claimed to be acting in the best interest of the child, exposing the stark hypocrisy of a system that purported to protect families while simultaneously subjecting them to immense trauma. But despite all this strategic maneuvering, ethical restructuring, and overwhelming empirical data, the mediation movement was still operating on the fringes of the dominant legal system. They had successfully survived the initial onslaught from the bar associations and carved out a defensive perimeter, but basic survival was not enough. To truly revolutionize American family law, they needed undeniable institutional legitimacy. They needed the massive court systems themselves to stop viewing them as an existential threat and start viewing them as the ultimate operational solution. And they were about to find that absolute legitimacy from the most unlikely, desperate source imaginable: a catastrophic systemic breakdown that would forcefully tie the hands of the very judges who had initially condemned them. The catastrophic systemic breakdown was a matter of pure, inescapable mathematics. By the late 1970s and early 1980s, the American cultural landscape was undergoing a massive seismic shift, and the divorce rate had skyrocketed to unprecedented historical highs. The sheer, staggering volume of marital dissolution filings completely overwhelmed the physical and administrative capacity of the state court systems. It was not merely a busy season, it was an absolute infrastructural collapse. Courthouses built in the 1920s to handle a fraction of the population were suddenly flooded with angry, terrified families demanding access to a judge. Dockets, which are the official schedules of court proceedings, became hopelessly backlogged. A couple filing for a routine divorce might be forced to wait 2 to 3 years just to get a preliminary hearing for temporary child support or a basic visitation schedule. During this extended waiting period, families were left in a state of paralyzing financial and emotional limbo. The adversarial system, already fundamentally flawed for family disputes, became a torture chamber of indefinite delays. This delay was not just inconvenient, it was highly destructive. Historical trends show that prolonged legal uncertainty exponentially increases post-separation hostility. Spouses, living in separate residences but legally tethered to the same frozen financial assets, often engaged in prolonged campaigns of psychological warfare. Judges, the supposed arbiters of justice, were drowning. A standard family court judge during this era might face a daily docket of 40 to 50 distinct cases. They had mere minutes to review complex financial affidavits, hear conflicting, highly emotional testimonies, and render immediate, binding decisions that would permanently alter the trajectory of a family. The psychological toll on the judiciary was immense. Judges privately admitted they were utterly unequipped to handle the deep psychological trauma of family dissolution, and the system forced them into a mechanism of rapid-fire, mechanized rulings that often left both parties deeply dissatisfied. The courts were desperate for a pressure release valve. This desperation forced a monumental shift in judicial behavior. The very same judges who had previously threatened mediators with the unauthorized practice of law suddenly realized that these fringe professionals possessed the exact skill set the court desperately lacked. Slowly, quietly, and entirely out of administrative necessity, individual judges began issuing informal referrals. If a judge saw a highly contentious child custody case that was consuming too much valuable courtroom time, they would pull the attorneys into chambers and strongly suggest that the couple consult with a mediator before returning to the bench. They did this because they noticed an undeniable historical trend. When couples went to these rogue mediators, they often did not come back. The cases were magically disappearing from the bloated court dockets, resolved through private negotiation and submitted purely for final administrative approval. The mediators were successfully clearing the backlog that was crushing the judicial system. This informal practice eventually crystallized into sweeping legislative action, marking the exact moment mediation transitioned from a subversive rebellion to an institutional pillar. Let us look at a critical case study. The state of California in 1981, recognizing the absolute devastation of the adversarial process on children, the California legislature passed a landmark piece of legislation that mandated mediation for all disputed child custody and visitation issues before the parents were legally permitted to see a judge. This was a watershed moment in American legal history. The state was officially admitting that the courtroom was a toxic environment for children, and that alternative dispute resolution was the superior, primary mechanism for family restructuring. This created the massive infrastructure of court-annexed mediation programs. Suddenly, courthouses were employing on-staff social workers and mental health professionals to intercept hostile couples right at the door. Imagine if an American citizen named Sarah in the current year 2026 files for divorce in a major metropolitan area like Chicago or Los Angeles. She might anticipate a dramatic, televised courtroom battle characterized by aggressive cross-examinations and sudden objections. Instead, the very first formal legal notice she receives from the county clerk is a mandatory, non-negotiable order to attend a mediation orientation session. She literally cannot secure a trial date with a judge until she and her estranged husband have exhausted the mediation process. The potential outcomes of her divorce are now heavily influenced by a system designed to de-escalate rather than attack. This modern reality, where peaceful negotiation is a mandatory prerequisite to litigation, is the direct descendant of the systemic collapse of the 1980s. The rebels had essentially hacked the legal operating system by proving they were the only viable solution to a terminal administrative crisis. However, forcing hostile couples into a room did not automatically generate peace. Traditional litigators, deeply resistant to losing their billable hours and courtroom control, immediately attempted to weaponize this new mandatory requirement. They developed a strategy of malicious compliance. Attorneys would instruct their clients to physically attend the mandated mediation sessions, sit with their arms crossed, refuse to compromise on a single issue, and simply wait out the clock so they could check the bureaucratic box and return to the litigation battlefield. To counter this, early court-appointed mediators had to develop highly sophisticated psychological frameworks to break down entrenched hostility in real time. They had to transition couples from a mindset of absolute warfare into a posture of reluctant collaboration within a matter of hours. They achieved this by completely reframing the narrative. Mediators refused to entertain debates about past marital grievances or assigning moral blame. If a husband tried to argue about his wife's past behavior, the mediator would ruthlessly redirect the conversation to the future developmental timeline of their children. They utilized advanced dispute resolution techniques, such as forced perspective shifting and reality testing, walking the parents step by step through the devastating financial and emotional outcomes of choosing a trial. They presented data-driven case studies demonstrating how long-term litigation fundamentally destroys college funds and retirement accounts. They forced the warring spouses to confront the stark, uncomfortable reality of their own destructive behavior in a neutral, controlled environment. This institutional integration gave the early adopters the absolute legitimacy they had fought so hard to achieve. They were no longer outlaws. They were an officially sanctioned arm of the justice system. The legal establishment had surrendered, admitting that the mediation model was not just effective, but entirely necessary for the survival of the courts. It was a massive, unprecedented victory for alternative dispute resolution. But this victory triggered a deeply complex and dangerous new phase. By embedding themselves within the machinery of the state, the mediators were suddenly exposed to the toxic bureaucratic standardization of the very legal system they were originally trying to escape. They had successfully breached the castle walls and forced the king to abdicate, but now they faced the terrifying reality of becoming the new establishment themselves. And as this new industry stabilized, the corporate financial sector began watching very closely, recognizing that mediation was no longer just a social movement, but a highly lucrative, scalable business model ripe for aggressive exploitation. The transition from a grassroots social movement into a formalized, highly lucrative industry happened with breathtaking speed. Once the state court systems essentially mandated alternative dispute resolution, the market dynamics fundamentally shifted overnight. The early adopters, who were primarily social workers, family therapists, and idealistic attorneys, suddenly found themselves standing at the epicenter of a massive guaranteed pipeline of clients. The state was literally forcing millions of divorcing couples to seek mediation services before they could access a judge. Where there is a state-mandated demand, corporate enterprise inevitably follows. The financial sector, always highly attuned to emerging markets, looked at the overwhelming volume of cases flowing through these new court annex programs and recognized an untapped goldmine. Mediation was no longer just an alternative method for communication and emotional de-escalation. It was suddenly recognized as a highly scalable business model that dealt directly with the massive transfer of generational wealth. To understand this corporatization, we have to look at the severe limitations of the original mediation pioneers. A brilliant family therapist might be exceptional at navigating the psychological trauma of a broken marriage, and they might be incredibly skilled at de-escalating a screaming match between hostile spouses. However, that same therapist was often entirely unqualified to execute the complex mathematical division of a defined benefit pension plan, or to accurately calculate the long-term capital gains tax liabilities associated with liquidating a massive stock portfolio. As the historical trends shifted and mediation gained popularity among wealthier demographics, the financial complexity of the cases skyrocketed. The early mediators were essentially flying blind when it came to advanced economics. If a couple agreed to a seemingly equal division of assets, one spouse might take the primary residence while the other took the retirement accounts. On paper, the split appeared 50-50, but without a sophisticated understanding of future tax implications and liquidity constraints, the spouse who took the house could easily face total bankruptcy within 5 years due to maintenance costs and property taxes, while the spouse with the retirement accounts watched their wealth compound. This critical vulnerability paved the way for a completely new class of professional to enter the arena: the financial specialist. During the late 1980s and early 1990s, we witnessed the rapid rise of the certified divorce financial analyst, an entirely new certification designed specifically to bridge the gap between emotional negotiation and hard economic reality. These financial professionals did not care about who was to blame for the divorce, they only cared about the math. They introduced highly sophisticated, predictive modeling software into the mediation room. Instead of simply dividing the current assets, these analysts would run complex, step-by-step algorithms projecting the financial survival of both spouses 30 years into the future. They accounted for inflation, fluctuating interest rates, the specific tax consequences of alimony versus child support, and the hidden penalties of early retirement withdrawals. The integration of these financial analysts transformed mediation from a psychological healing process into a rigorous, data-driven financial restructuring. Imagine if an American citizen named Robert in the current year 2026 decides to mediate his divorce. He does not walk into a cozy therapist's office with comfortable couches and a box of tissues. Instead, Robert walks into a sleek, high-tech corporate boardroom. He sits across from a mediation team that includes a neutral facilitating attorney and a dedicated financial analyst. On a large monitor, the team projects a detailed Monte Carlo simulation, running thousands of automated scenarios to show Robert exactly what his potential outcomes will be if he chooses to keep his restricted stock units versus trading them for equity in the marital home. Robert is receiving a level of bespoke financial planning that was completely unavailable to the public in the early days of family law. This modern scenario is the direct result of the financial sector hijacking the mediation movement and injecting it with corporate-level data analytics. It makes the process incredibly efficient, highly accurate, and exponentially more expensive. As these specialized financial roles became standard practice, the barrier to entry for establishing a mediation firm significantly increased. It was no longer enough to be a good listener. You needed specialized software, a team of cross-disciplinary experts, and a massive marketing budget. This led directly to the aggressive corporatization of the industry. Venture capital and private equity firms began identifying successful, independent mediation practices and buying them out, consolidating them into massive national franchise models. These corporate entities applied strict business optimization strategies to the deeply personal process of divorce. They standardized the intake procedures, utilized boilerplate templates for the Memorandum of Understanding to save time, and instituted rigid hourly billing structures that closely mirrored the very law firms the early adopters had rebelled against. They began offering tiered service packages, where a basic, inexpensive package provided minimal human interaction and heavily relied on automated online dispute resolution tools, while the premium, highly expensive packages offered the full suite of specialized financial and legal consultants. The original pioneers of the movement watched this transformation with profound horror. A deep ideological civil war erupted within the mediation community. The grassroots early adopters argued that the corporatization of the process completely destroyed the soul of mediation. They believed that by heavily relying on standardized templates and rushing couples through a corporate assembly line, the industry was stripping away the vital, human element of self-determination. They argued that a massive corporate franchise, driven entirely by profit margins and case turnover metrics, had no real interest in the long-term emotional stability of the families they were processing. The corporate mediators fired back, arguing that the early adopters were hopelessly naive. They pointed to historical case studies proving that without rigorous financial standardization and corporate efficiency, millions of couples would simply fall back into the catastrophic delays of the traditional court system. The corporations argued they were democratizing access to high-level financial uncoupling, even if it meant sacrificing the intimate, therapeutic environment of the past. This philosophical divide split the industry into two distinct factions: the therapeutic mediators who focused on the relationship, and the evaluative mediators who focused strictly on the transaction. The corporate model heavily favored the transactional approach because it was faster, easier to measure, and highly profitable. They built massive marketing machines, dominating internet search results and heavily advertising their services as the fastest, cheapest way to bypass the courtroom. They successfully commodified the dissolution of the American family. But as these massive mediation conglomerates rapidly scaled their operations to handle thousands of cases a year, they inadvertently created a massive systemic blind spot. By relying so heavily on standardized financial models and automated processes, they assumed that every client would voluntarily provide accurate, truthful financial data. They built their entire business model on the foundational assumption of mutual transparency. They were completely unprepared for the reality that a new generation of high-net-worth individuals, equipped with incredibly complex financial portfolios, offshore accounts, and aggressive shell companies, would use the confidentiality of the mediation room not to negotiate fairly, but to execute the most sophisticated financial deception in the history of American family law. This sophisticated deception fundamentally exploited the core architectural pillar of mediation, the honor system. To comprehend how easily high-net-worth individuals began weaponizing the mediation room, we must deeply analyze the structural differences in legal discovery between the traditional court system and alternative dispute resolution. Traditional litigation, for all its destructive adversarial flaws, possessed one incredibly powerful, historically proven tool for truth extraction. That tool was the legally binding subpoena, backed by the full force and punitive threat of the judicial branch. In a standard litigated divorce, attorneys possess the statutory authority to force banks, brokerage firms, corporate employers, and business partners to surrender highly sensitive financial documents directly to the court. Furthermore, spouses are subjected to rigorous depositions, placed under oath by a court reporter, and forced to answer highly invasive financial questions under the direct threat of criminal perjury charges. If a spouse is caught hiding assets in a litigated setting, the judge has the unilateral authority to sanction them, award the entirety of the hidden asset to the opposing spouse, or even incarcerate the offending party for contempt of court. Mediation, however, stripped all of these compulsory mechanisms away in the name of peace and efficiency. The corporate mediation models that dominated the landscape relied entirely on a process called voluntary financial disclosure. Instead of issuing subpoenas, the corporate mediators provided clients with a standardized spreadsheet or access to an online portal. The spouses were simply asked to list their assets, liabilities, incomes, and expenses. The foundational assumption of the corporate model was that because the parties had chosen a peaceful resolution, they would naturally act in good faith. If a spouse did not write an asset down on the spreadsheet, the specialized software algorithms and the highly paid certified divorce financial analysts could not analyze it. The mediator, bound by strict rules of neutrality, was legally prohibited from acting as a private investigator. If a wife did not explicitly know to ask her husband about a specific offshore bank account, the mediator could not pause the session and launch an independent forensic audit on her behalf. The mediator could only facilitate a conversation based entirely on the reality presented to them on that voluntary spreadsheet. Imagine if an American citizen named Emily in the year 2026 is mediating her divorce with her husband Richard. Richard is an executive at a mid-sized technology firm and has spent the last 5 years quietly preparing for this marital dissolution. On paper, their shared marital estate appears to be worth approximately $4 million, consisting of a primary residence, standard 401k accounts, and joint checking balances. Emily trusts the corporate mediation process because the marketing materials emphasized its thorough, data-driven approach. Richard diligently fills out his voluntary financial affidavit, listing exactly what Emily already knows about. The financial analyst runs their impressive Monte Carlo simulations. The neutral attorney drafts a highly detailed memorandum of understanding, and Emily agrees to a seemingly fair $2 million settlement. What the corporate mediation team failed to uncover, because they were structurally not designed to look for it, was that Richard had systematically siphoned an additional $3 million out of the marital estate over the preceding 48 months. Relying on historical trends of wealth obfuscation, Richard did not use simple, easily traceable domestic bank transfers. Instead, he utilized complex mechanisms designed to bypass standard financial scrutiny. He overpaid his federal taxes for 3 consecutive years, essentially using the Internal Revenue Service as a zero-interest holding account, intending to claim the massive refund only after the divorce was finalized. He funneled a portion of his executive bonus structure directly into a decentralized cryptocurrency hardware wallet that was entirely detached from his social security number and traditional banking profile. Furthermore, he established a Nevada Asset Protection Trust, legally transferring ownership of a lucrative side business to a third-party trustee, effectively removing the asset from the legal definition of the marital estate under the laws of his specific state. Because Richard brought his neat, intentionally incomplete spreadsheet to the mediation table, the entire corporate machine validated his deception. The system designed to protect families financially became the exact instrument of Emily's financial ruin. Case studies from the early 2000s through the present day demonstrate a disturbing historical trend of post-divorce litigation stemming directly from mediation fraud. Spouses who chose the collaborative route out of a desire to save money on legal fees frequently discovered, years after the final decree was signed, that they had been manipulated out of massive generational wealth. The legal trap for these defrauded spouses was incredibly severe. Overturning a finalized, mediated settlement agreement is historically one of the most difficult legal maneuvers in American family law. Because the state heavily favors the finality of contracts, courts operate on the presumption that a signed agreement is legally binding, especially if both parties were offered the opportunity to have consulting attorneys review the document. To reopen a case based on hidden assets, the defrauded spouse must shoulder the immense burden of proving deliberate, intentional fraud, not merely an accidental omission. They are forced to re-enter the adversarial court system they originally tried to avoid, now heavily disadvantaged and required to fund highly expensive forensic accountants and aggressive litigators to prove the deception occurred during the original mediation. This terrifying vulnerability created a massive crisis of credibility for the mediation industry. High-net-worth individuals and their financial advisors began publicly warning against the dangers of voluntary disclosure. The corporate model's promise of a fast, cheap, and amicable divorce was increasingly viewed as a dangerous playground for financial predators. The original pioneers of the movement, along with a new generation of legal scholars, realized that if mediation could not guarantee financial truth, it would eventually be discarded by the public as an unsafe mechanism for dispute resolution. They had to pivot once again. They needed to invent a completely new hybrid framework that somehow combined the mandatory, aggressive truth extraction mechanisms of traditional litigation with the peaceful, self-determined resolution of mediation. To accomplish this seemingly impossible task, they had to breach the most sacrosanct, foundational rule of the mediation room itself, setting the stage for a controversial legal maneuver that would redefine the boundaries of professional confidentiality. The sacrosanct rule of the mediation room was the doctrine of absolute, impenetrable confidentiality. To understand the gravity of breaching this rule, you must understand its historical origins. In the early days of alternative dispute resolution, legal pioneers recognized that spouses would never truly open up, admit fault, or propose creative compromises if they feared their words would later be used against them in a public courtroom. State legislatures across the country agreed, codifying mediation privilege into law. This privilege functioned very much like attorney-client privilege or the priest-penitent privilege. It mandated that absolutely nothing said, offered, or produced within the physical boundaries of a mediation session could ever be subpoenaed, entered into the public record, or used as evidence in a future trial. If a husband tentatively offered to surrender a portion of his retirement account to secure a better custody arrangement, and the mediation ultimately failed, the wife could not go to a judge and testify about that offer to prove his financial capabilities. This absolute legal shield was the architectural bedrock of the process, designed to foster extreme human vulnerability and radical candor. But as the industry corporatized and high-net-worth individuals entered the system, this exact legal shield, constructed to protect emotional honesty, was perfectly weaponized to protect severe financial criminality. Because the spreadsheets and financial disclosures provided in mediation were technically produced for the purpose of settlement, they were historically covered under this blanket of confidentiality. If a defrauded spouse discovered hidden assets years later, they faced an impossible legal paradox. They knew their former partner had lied on the mediation spreadsheet, but state evidence codes explicitly prohibited them from showing that specific spreadsheet to a judge. The corporate mediation models had inadvertently built an untraceable darkroom for financial fraud. To save the institutional integrity of the movement, progressive legal scholars and advanced mediators realized they had to execute a highly controversial maneuver. They had to systematically pierce the veil of confidentiality without destroying the psychological safety of the entire process. They achieved this through the invention of the conditional fraud exception, fundamentally altering the standard contract that couples signed before entering the room. Before a single word of negotiation occurred, both parties were now required to sign a binding legal waiver that explicitly separated their emotional statements from their financial data. The new legal framework dictated that while all verbal negotiations, apologies, and settlement propositions remained strictly inadmissible in court, the actual financial affidavits and asset spreadsheets submitted during the process were entirely stripped of their confidential status if subsequent financial deception was uncovered. This meant that the voluntary disclosure form was suddenly elevated to the legal equivalent of a sworn testimony under penalty of perjury. If you lied on the paper in the private room, that specific piece of paper would absolutely be handed over to a judge as undeniable documentary evidence of intentional fraud. But changing the legal contract was only the first step. To enforce this new standard of aggressive transparency, the industry had to introduce a new apex predator to the mediation table. This marked the integration of the neutral forensic accountant. Unlike the traditional financial analysts who simply trusted the numbers provided to them and ran futuristic projections, the forensic accountant was an investigative specialist deeply trained in historical asset tracing and financial unearthing. They fundamentally shifted the mediation dynamic from an honor system to a rigorous protocol of trust but verify. The step-by-step details of this new hybrid protocol were intensely invasive. The forensic accountant did not simply ask for a list of bank accounts. They required the divorcing couple to sign direct authorization forms, allowing the neutral financial team to pull official tax transcripts directly from the federal government, completely bypassing the spouse's hands. They mandated read-only digital access to all domestic banking institutions and brokerage houses. Most importantly, they executed a comprehensive forensic lifestyle analysis. This process meticulously compared the family's declared annual income against their actual, verifiable expenditures. By examining credit card statements, property tax records, travel histories, and real estate acquisitions, the accountant calculated the exact monthly burn rate of the family. If a spouse claimed a business income of $100,000 a year, but the lifestyle analysis proved the family was somehow spending $300,000 a year without accumulating massive debt, the forensic accountant instantly knew that significant assets or hidden revenue streams were being actively concealed. Imagine if an American citizen named Thomas in the current year 2026 enters this modern, legally binding hybrid mediation process. Thomas operates a highly lucrative network of e-commerce businesses and has spent the previous 2 years systematically funneling revenue into complex offshore holding companies and decentralized digital cryptocurrency ledgers. He assumes the modern mediation room will operate like the corporate models of the past, simply accepting his artificially deflated personal income statement. But under the modern forensic protocols, before any discussion of asset division can begin, the neutral financial investigator deploys advanced blockchain tracing software and cross-references Thomas's declared business revenue against his verifiable vendor payments and shipping manifests. The analysis instantly flags a massive, unaccounted-for discrepancy in the cash flow. Because Thomas signed the modern conditional waiver, his failure to disclose this wealth is entirely unprotected. He is cornered by his own data. He faces a stark binary choice. He can immediately surrender the hidden ledgers, integrate the offshore funds into the marital estate, and negotiate fairly, or he can face the potential outcomes of the mediator permanently terminating the private session and the forensic audit report being forwarded directly to a litigating attorney as a fully admissible roadmap for civil fraud prosecution. This structural evolution completely changed the power dynamics of alternative dispute resolution in the United States. State legislatures began actively revising their family law statutes to explicitly support these carved-out exceptions, publicly recognizing that alternative dispute resolution could never be permitted to serve as a state-sanctioned safe harbor for financial manipulation. The historical trends show that as this rigorous forensic model became the gold standard for complex estates, the rates of post-divorce litigation based on hidden assets plummeted dramatically in jurisdictions that adopted it. The hybrid model successfully proved that you could mandate the aggressive truth extraction mechanisms of a courtroom while still preserving the peaceful, self-determined resolution environment of the mediation table. The financial loophole was finally effectively closed. The spreadsheets were verified, the hidden offshore accounts were exposed, the complex tax liabilities were accurately calculated, and the fundamental math of the marital dissolution was finally anchored in absolute, undeniable reality. But this massive victory for financial transparency triggered a deeply disturbing, unintended consequence. By systematically stripping away the ability to execute financial deception, the new hybrid system inadvertently funneled all the toxic, unresolved marital hostility directly into the one specific area the forensic accountants were completely powerless to audit. The ledgers were clean, but the psychology of the participants was about to turn incredibly dark. The highly efficient corporate and forensic models had completely ignored the terrifying reality of high-conflict personality disorders. The mediators were about to realize that when a deeply entrenched narcissist is trapped in a room and can no longer hide their money, they immediately begin to hide, manipulate, and weaponize the children. The transition from financial obfuscation to the weaponization of children represented the most treacherous era in the history of alternative dispute resolution. When the forensic accountants successfully closed the financial loopholes, the battlefield did not disappear. It merely shifted to a landscape where the collateral damage was measured in human developmental trauma. The foundational premise of early mediation was built on a deeply optimistic, perhaps profoundly naive assumption about human nature. The original pioneers, heavily rooted in therapeutic backgrounds, operated on the core belief that regardless of the intense marital hostility, both spouses ultimately loved their children more than they hated each other. They believed that if you provided a safe, structured environment, parents would naturally prioritize the psychological well-being of their offspring. But historical case studies from the late 1990s rapidly exposed the terrifying flaw in this logic. Mediators were encountering a specific demographic of individuals who fundamentally inverted this premise. These were individuals with severe, deeply entrenched high-conflict personality structures, including covert narcissism, antisocial traits, and borderline personality disorder. For a high-conflict individual, the destruction of the former partner is the primary objective, and they will absolutely sacrifice the emotional stability of their own children to achieve it. To understand how this operates within the mediation room, we must examine the specific mechanics of coercive control. Traditional mediation techniques rely heavily on interest-based negotiation, where the neutral facilitator attempts to uncover the shared goals of both parties. But how do you negotiate when one party's sole underlying interest is the total psychological annihilation of the other? You cannot. When a high-conflict personality is stripped of their financial dominance by rigorous forensic auditing, they immediately pivot their strategy to target the exact source of their ex-spouse's greatest vulnerability. They begin to demand entirely unreasonable custody arrangements, not out of a genuine desire to parent, but as an instrument of pure leverage. They recognize that an empathetic, healthy parent will trade virtually any financial asset to secure the safety and stability of their children. The mediation table suddenly transforms into an arena for state-sanctioned extortion. Imagine if an American citizen named Amanda in the current year 2026 is trapped in a mediation room with her estranged husband Marcus. Marcus possesses classic, undiagnosed high-conflict traits. The hybrid forensic model has completely dismantled his attempts to hide his lucrative stock portfolio, meaning the math of the divorce is settled. Sensing his loss of control, Marcus executes a calculated pivot. He suddenly files a formal demand for full physical custody of their 2 young children, demanding that Amanda be restricted to supervised weekend visitations. He has no evidence to support this restriction, but he knows the corporate mediation model requires the neutral facilitator to treat every demand as a valid, negotiable position. Amanda is thrown into an absolute panic. She is now forced to negotiate for the basic right to see her own children, treating them as chips in a high-stakes poker game. Marcus uses this terror to stall the process, refusing to sign any agreements, forcing Amanda to drain her legal retainers, and systematically grinding down her psychological endurance. If Amanda capitulates and surrenders her rightful share of the financial estate just to make the custody threat disappear, the mediation process has fundamentally failed her. It has facilitated her abuse. Historical trends analyzed by family court researchers during this era revealed a catastrophic systemic vulnerability. Studies indicated that approximately 10% of divorcing couples were consuming over 90% of the judicial system's resources, and these were almost exclusively high-conflict cases. When courts mandated these specific cases into standard mediation programs, the potential outcomes were often disastrous. Standard mediators were trained to remain entirely neutral, but in a dynamic involving a psychological abuser and an abused victim, remaining strictly neutral effectively empowers the abuser. If one person is negotiating in good faith and the other is utilizing gaslighting, projection, and subtle threats of alienation, a mediator who merely reflects their statements back at them is complicit in the trauma. The abuser easily manipulates the structural neutrality of the room to maintain their coercive control, entirely unchecked by the legal system. The weaponization of the children took deeply insidious forms. High-conflict individuals would use the confidential nature of the mediation sessions to make terrifying, off-the-record threats. They would threaten to move the children out of state, to file false allegations of abuse with Child Protective Services, or to engage in systematic parental alienation. Parental alienation is a severe form of psychological abuse where one parent actively brainwashes the child into fearing, rejecting, and hating the targeted parent, completely rewriting the family history to cast themselves as the sole victim and savior. Because these threats were made under the legal shield of mediation privilege, the targeted parent could not report them to a judge. The very confidentiality meant to encourage peaceful settlement became a soundproof room for psychological torture. The progressive wing of the mediation movement realized they were facing an existential crisis. They had successfully built an alternative to the traditional court system, and they had successfully integrated forensic accounting to stop financial fraud, but they were fundamentally unequipped to handle clinical psychological pathology. The standard toolkit of active listening, reframing, and future-focused brainstorming was completely useless against a sociopath. If the mediation industry could not find a way to safely manage high-conflict personalities, these toxic cases would continuously spill back into the already overwhelmed family court system, resulting in devastating multi-year litigation wars that destroyed the childhoods of the most vulnerable citizens. The early adopters knew they had to rip up the standard playbook. They had to invent an entirely new architectural framework specifically designed for the high-conflict demographic. This required a profound philosophical shift. They had to abandon the sacred idol of absolute neutrality and transition into a posture of highly structured, protective authority. They needed a mechanism to instantly halt coercive control, expose parental alienation in real time, and legally bind the high-conflict individual to a rigid, impenetrable co-parenting framework that offered zero room for manipulation. To achieve this unprecedented level of control outside of a courtroom, the industry had to introduce a radically new, highly specialized professional to the mediation table, a psychological operative possessing the statutory power to completely override the parents and mandate compliance in the name of the child. This new intervention was about to face the ultimate test, and the exact methods they deployed to break the narcissist's grip would forever alter the trajectory of American family law. The introduction of this highly specialized operative marked the birth of the parenting coordinator, a role that fundamentally shattered the traditional boundaries of alternative dispute resolution. To comprehend the immense power wielded by a parenting coordinator, you must understand that they are not mediators in the classical sense. A traditional mediator is a neutral facilitator who relies on the voluntary cooperation of both parties to reach a consensus. However, historical trends from the late 1990s and early 2000s conclusively proved that high-conflict personalities, particularly those exhibiting covert narcissistic or sociopathic traits, view voluntary cooperation as an opportunity for exploitation. They weaponize the inherent patience of the standard mediation process to exhaust their victim financially and psychologically. Therefore, the architectural framework of the parenting coordinator was intentionally designed to be entirely immune to this manipulation. This professional is a hybrid entity, part psychological evaluator, part fierce child advocate, and part quasi-judicial arbitrator. When a court appoints a parenting coordinator, or when a desperate divorcing couple legally binds themselves to one through a specialized mediation clause, the foundational rules of engagement change instantly and irrevocably. The most critical evolution was the transition from voluntary consensus to binding arbitration. If a highly entrenched, high-conflict individual attempts to stall a negotiation regarding a holiday custody schedule or a medical decision for the child, the parenting coordinator does not waste time attempting to unearth their underlying emotional interests. Instead, the operative relies on a highly structured, data-driven protocol. They evaluate the immediate developmental needs of the child, review the psychological history of the parents, and then they unilaterally make the decision. They issue a binding directive that carries the legal weight of a court order. This mechanism strips the high-conflict individual of their primary weapon, which is the ability to paralyze the family system through endless circular arguments. By removing the necessity for agreement, the parenting coordinator neutralizes the extortion dynamic. Let us deeply examine a specific scenario utilizing an American citizen named Jessica in the year 2026. Jessica is attempting to finalize a highly contested divorce from her ex-husband William. William has a documented historical trend of utilizing coercive control. He frequently arrives late for custody exchanges to induce anxiety, he intentionally disrupts the children's routines, and he communicates exclusively through massive, abusive text messages designed to trigger a trauma response in Jessica. In a traditional mediation setting, William would use his allotted speaking time to gaslight Jessica, twisting the narrative to portray himself as the victim of her supposed inflexibility. But Jessica and William have been assigned a parenting coordinator. The very first action the coordinator takes is completely severing all direct, unmonitored contact between the parents. The operative mandates the use of a specialized, court-monitored communication portal. This software permanently records every single keystroke, tracks the exact time messages are read, and utilizes artificial intelligence to flag hostile or manipulative language before the message can even be delivered. When William attempts to send a manipulative message, the system intercepts it. When he attempts to arrive late for a custody exchange, the parenting coordinator requires him to check in via a GPS-enabled application, creating an undeniable, time-stamped digital footprint of his behavior. The coordinator does not argue with William about his intentions. They simply document the behavioral data. When William attempts to deploy the classic psychological tactic of denying his behavior, attacking Jessica, and reversing the roles of victim and offender, the coordinator presents the irrefutable digital evidence. If William refuses to comply with the established parenting schedule, the coordinator does not suggest a compromise. They immediately issue a legally binding modification to the custody arrangement, strategically reducing his access to the children until he demonstrates measurable behavioral compliance. The operative effectively builds a psychological containment unit around the high-conflict parent, protecting the targeted spouse and shielding the children from the toxic fallout. Furthermore, the parenting coordinator is explicitly trained to identify and dismantle the insidious mechanics of parental alienation in real time. Historical case studies demonstrate that alienating parents often use incredibly subtle mechanisms to brainwash their children, such as passive-aggressive sighing when the other parent is mentioned, allowing the child to read inappropriate legal documents, or forcing the child to act as a spy within the targeted parent's home. The coordinator possesses the clinical authority to interview the children independently, coordinate with school counselors, and review medical records to identify the earliest clinical markers of alienation trauma. If they detect that one parent is actively attempting to sever the child's attachment to the other parent, they deploy immediate, aggressive interventions. These interventions often involve implementing a step-up parenting plan. This is a deeply structured timeline that slowly and safely reintegrates the targeted parent back into the child's life under heavy clinical supervision, while simultaneously mandating intensive psychological therapy for the alienating parent. This aggressive, highly interventionist model fundamentally saved thousands of children from severe emotional destruction. It provided a vital functional off-ramp for the family court system, allowing judges to outsource their most toxic, unmanageable cases to specialized mental health operatives. The legal community, initially terrified by the concept of granting quasi-judicial authority to therapists, eventually recognized that the traditional mechanisms of due process were fundamentally incapable of moving fast enough to protect the developing brain of a child trapped in a war zone. State legislatures began actively drafting new statutes to codify the authority of parenting coordinators, officially integrating them into the permanent architecture of American family law. The mediation movement had successfully evolved from a grassroots rebellion into a highly sophisticated, multidisciplinary ecosystem. They had integrated advanced financial modeling to completely eradicate asset hiding, and they had deployed binding psychological operatives to neutralize high-conflict personality disorders. They had built the ultimate comprehensive alternative to the American courtroom. But this architectural triumph carried a devastating, deeply hidden consequence. By constructing a flawless, highly specialized dispute resolution machine, the early adopters inadvertently triggered a massive economic crisis within their own industry. The process was now incredibly effective, but it required the simultaneous deployment of neutral facilitating attorneys, certified divorce financial analysts, forensic accountants, and binding parenting coordinators. As this army of professionals gathered around the modern mediation table, a terrifying new reality began to emerge, setting the stage for a final catastrophic reckoning that would force the entire system to question who actually had the financial right to a peaceful divorce. This terrifying new reality was a matter of basic, brutal economics. The modern, fully integrated mediation team was an architectural triumph of dispute resolution, successfully mitigating almost every single vulnerability of the earlier models. But this perfection came at an astronomical financial price. To secure the absolute protection of this gold standard process, a divorcing couple now had to simultaneously employ a small army of highly specialized professionals. Let us deeply examine the actual mathematical breakdown of a comprehensive hybrid mediation in a major American metropolitan area. You have the lead mediator, typically a senior attorney or clinical psychologist, billing at an average of $500 per hour. You add the neutral certified divorce financial analyst to run the 30-year financial projections, billing at $400 per hour. If there are any allegations of hidden assets, you must bring in the forensic accountant at an additional $400 per hour. Finally, if the case involves high-conflict personality traits, the legally binding parenting coordinator requires another $300 per hour. Before a single agreement is even drafted, the baseline operating cost of the mediation room can easily exceed $1,600 for every single hour the couple spends at the table. A complex negotiation taking 30 to 40 hours to finalize can rapidly consume $50,000 to $80,000 of the marital estate. The profound historical paradox here is inescapable. The original, rogue pioneers of the 1970s risked their professional licenses to invent alternative dispute resolution specifically because traditional litigation was bankrupting American families. Yet, by rigorously evolving the process to include impenetrable financial audits and ironclad psychological safeguards, the modern mediation industry inadvertently reconstructed the exact same massive financial barrier, merely rebranding it under a different operational title. This economic escalation created a severe, deeply entrenched two-tiered system of family justice across the United States. High-net-worth individuals possess the liquid capital to purchase privacy, secure surgical financial uncoupling, and shield their children from trauma using the elite multidisciplinary model. The working and middle classes, however, were abruptly priced out of the peace they were promised. Imagine if an American citizen named Christopher in the current year 2026 is a public high school teacher navigating a divorce with his wife, a registered nurse. They share a modest marital estate consisting of a primary residence with partial equity, standard state pension plans, and 2 adolescent children. Christopher deeply understands the historical trends and the catastrophic potential outcomes of traditional courtroom litigation. He desperately wants to bypass the adversarial system to protect his family. He researches the modern hybrid mediation model, but upon initial consultation, he is presented with a required upfront team retainer of $25,000. Christopher and his wife do not possess complex offshore corporate entities requiring a forensic audit, nor do they exhibit the severe sociopathic traits requiring a binding parenting coordinator. Yet, the massive corporate mediation franchises often heavily push these bundled, premium safeguards as mandatory operational standard operating procedures. Christopher is effectively walled off from the elite tier of peaceful resolution. Because they cannot afford the gold standard, middle-class families like Christopher are frequently forced into the second, highly dangerous tier of modern dispute resolution: the fully automated, low-cost online mediation platforms. Recognizing the massive gap in the market, corporate tech sectors developed algorithmically driven portals where couples can bypass human professionals almost entirely. In this tier, spouses simply log into a digital interface, utilize drop-down menus to list their assets, and use sliding digital scales to propose child custody percentages. The platform then utilizes predictive algorithms to automatically generate a final memorandum of understanding. While this costs a fraction of the price of human-led mediation, the potential outcomes are historically fraught with danger. We have already examined how voluntary financial disclosure without rigorous human verification invites catastrophic fraud. By pushing the middle class into this automated tier, the system practically guarantees that systemic power imbalances, subtle financial abuse, and coercive control will go entirely unchecked by a neutral, observing human being. Recognizing this massive ethical failure and the looming access to justice crisis, a new generation of legal innovators began to mobilize. These modern pioneers realized that the multidisciplinary fortress needed to be aggressively dismantled and democratized. They recognized that while the comprehensive, expensive model was absolutely necessary for high-conflict and ultra-high net worth demographics, the vast majority of American citizens simply needed a streamlined, highly regulated, and affordable pathway. This led to the widespread historical trend of legal unbundling, also known as limited scope representation. Instead of demanding massive, open-ended retainers, modern progressive mediators and legal consultants began offering flat-fee, targeted interventions. A couple could hire a neutral financial specialist strictly for a single, 2-hour session to untangle a complex pension, without being forced to retain them for the entire duration of the divorce. Furthermore, community-based, nonprofit dispute resolution centers began aggressively securing state and federal grants to provide trauma-informed mediation on a strict sliding income scale. The most significant structural shift came when progressive state Supreme Courts began actively revising their unauthorized practice of law statutes once again. This time, they created specialized licensing for non-lawyer legal navigators. These highly trained professionals possess the statutory authority to guide self-represented couples through the overwhelming bureaucratic maze of family court filings and basic mediation frameworks, entirely bypassing the exorbitant billable hours of the traditional legal establishment. The historical arc of divorce mediation in America is a profound, deeply complex case study in the evolution of social justice and legal architecture. It began as a quiet, subversive rebellion by mental health professionals who refused to accept the state-sponsored emotional violence of the traditional courtroom. They survived coordinated attacks from powerful bar associations, adapted to handle the crushing infrastructural collapse of the court systems in the 1980s, and successfully integrated advanced financial and psychological operatives to protect families from the darkest elements of human deception. These early adopters fundamentally altered the cultural landscape of the United States. They empirically proved that the dissolution of a legal partnership does not mandate the destruction of the human beings involved, giving millions of people the absolute right to legally own their transition. But as we stand in the reality of 2026, the foundational framework these pioneers built is facing an unprecedented, existential technological challenge. With the rapid, unchecked deployment of advanced artificial neural networks into the legal sector, we are no longer merely asking who has the financial right to a peaceful divorce. We are actively asking if human beings should even be facilitating these intensely emotional negotiations at all. Imagine a rapidly approaching scenario where a perfectly unbiased, highly advanced predictive algorithm evaluates your entire marital history, instantly calculates your exact financial trajectory, and dictates your child custody arrangement with absolute, unfeeling mathematical precision, completely eliminating human bias but also entirely erasing human empathy. Will this algorithmic revolution be the ultimate, perfect democratization of family law? Or will it be the final, terrifying surrender of human intimacy to the machine? We will deeply analyze exactly how artificial intelligence is quietly rewriting the fundamental laws of human separation, and what you must do to protect your family from the algorithm, in our next comprehensive investigation.